Hi everyone, in this week's video we are discussing post-termination restrictions and an unusual one, or a more unusual one than many businesses will seek to restrict, and that is where a business wants to stop an employee working for a particular client. So ordinarily we will have, at the most severe end, potentially a non-compete clause, so that prevents an employee going to a direct competitor or setting up his own entity in competition. We would then have a series of non-solicitation and potentially non-dealing provisions which relate to soliciting or enticing the custom of restricted clients, normally those who the employee has had direct dealings with, and also maybe key members of staff. But the question we're answering in this video is whether or not an atypical restriction could prevent an employee from going to work for a particular client or customer who they've had dealings with in the past. And surprisingly, there's very little case law on the issue. The key, I think, is to analyse this type of restriction in just the same way as the others. And the starting point is that all post-termination restrictions are a restraint of trade. That is, unless the employer can show that they are going no further than is reasonably necessary to protect a legitimate proprietary interest. So in this case, what could that proprietary interest be? Some examples are trade connections, confidential information, trade secrets, the stability of the workforce if a particular client is lost who may generate substantial income for the particular employer. If the employer can conclude that those interests will be infringed significantly by virtue of the employee being permitted to go and join that customer, they would then have to get over the threshold of whether or not there are any other restrictions which are less restrictive, which might have the same effect, so might protect those interests adequately. In general, I think this is going to apply where there is a specific customer who takes a significant percentage of a business's income. So, for example, in the legal world, if a lawyer acts for a number of individual clients and one of those makes up 80% of that team's workload and income, it may be more reasonable to protect that income by virtue of a non-employment clause such as this, as opposed to all clients and customers who that lawyer has ever worked with. Because if that was breached and the lawyer did go and work in-house at a particular client, that could have a catastrophic impact on the stability of the workforce, as an example, because of all that income being lost. So it's not particularly clear. Unfortunately, we don't have a huge thread of case law. Many businesses will include this clause simply as a deterrent. Many businesses will also ensure that in any terms of business they have with a particular key client, the client themselves is prohibited from soliciting the employment of one of the business's individuals, and there may even be a clause that prevents employment altogether. I hope that's helpful. If you do need any bespoke drafting advice in this area or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.